There we go. Sorry about that. We're going to go ahead and start working 2528. With that, we will, is Jenna ready for an overview of 2528?
Thank you, Mr. Chair. House Bill 2528 is about the Board of Nursing and would make significant changes in regards to voiding of past unprofessional conduct, allows for late license renewal up to 90 days after the renewal date, would limit unprofessional conduct definition to acts related to the practice of nursing, prohibits the board from taking retaliatory action based upon lawful acts. It creates some civil actions against the board in regards to some of the prohibitions, and then would also require that the board members be subject to Senate confirmation.
Committee questions? Seeing none? Okay, discussion. Go ahead. Representative Weichel.
Thank you, Mr. Chair. A procedural question. I have an amendment to bring, but there's not a motion on the table. So do we need a motion?
We need a motion for your amendment, but we don't need a motion to work the bill.
We need a motion to pass out the bill and then discussion.
I'd make a motion to pass out 2528. Second by Representative Bryce. All in favor say aye. Aye. Okay. All right. Now discussion. You know, we've had this. Representative Weichel.
Thank you, Mr. Chairman. I think we're all ready to go home this weekend. Following the hearing on this bill, I had a lot of unanswered questions personally about what Section 1 was actually voiding and what it was not voiding. I spent some time with the revisor going through each of the statutes and regulations that was listed, and it's my understanding from that conversation that as the bill is written, it's very expansive in terms of what it would void beyond clerical errors. Many things, if not all, violations of the Nurse Practice Act. And so I think we're all concerned about making sure patient safety is number one. And with that, I have an amendment for Section 1 to clarify that language.
Thank you. Do I have a second? Second. Second by Representative Reeves. Would you please explain your amendment while it's being passed out?
Yes. So my amendment takes the language from lines 22 and 23 on page 1, which states, only if such action or record arises from or is related to applications for licensure or license renewal. And it moves that same language to the prior paragraph to ensure that that language applies to all of the statutes and regulations that are listed below that. And the intent here, I'll say, is to really clarify that this would only be voiding those clerical errors that we heard about at times of renewal. And I also did speak with Representative Pickert about this amendment this morning, and she expressed her support for it.
Thank you. Representative Blex.
Thank you, Mr. Chair. Thank you, Representative, for that amendment. But that really doesn't address I think the intent of this committee is to determine the guilt and the innocent, and I don't think that your amendment will address issues to where a provider is falsely accused, which is very easy to be done by another provider, or anybody else can falsely be accused and not be totally guilty and suffer, as in the case of my wife, about $10,000, $12,000 later for something she wasn't guilty of a license. So I guess I'm going to be opposed to this amendment simply on that because it doesn't address, and I understand the voiding. There's a lot of things in there that shouldn't be voided. You know, some of the issues that the director of nursing gave us are the worst, and certainly, but I would hate to just say restrict it to license and applications only and license renewal, because there's a lot of other people out there, and we got tons of reports that indicate that. So thank you.
Further discussion, committee.
Thank you, Mr.
President
Chair.
Bueller.
And I guess with respect to the amendment, and I'm looking at, I'm trying to make sense of all the statutes here, and I guess maybe this is, pardon me, I'm wearing cheater glasses I borrowed from somebody else. I'm trying to make sure, or maybe get a clarification from the revisers. There are numerous statutes that are listed in HB 2528. So my question would be, is the amendment, does it address all of the statutes that are listed, or does it just address a couple of them?
Jenna?
Thank you, Mr. Chair. The amendment would apply to all of those statutes and regulations that are listed. So the only disciplinary actions that would be voided would be ones where essentially one of these statutes or regulations were cited in that disciplinary action related to licensure or license renewal. So you renew your license late, you get a action for unprofessional conduct, and it cites one of these statutes, that would apply, that would still be void. But if it's related to, I don't know, misuse of medications or related to abusing a patient, that would not, even if it's cited as unprofessional conduct, then that wouldn't be void under this action.
Thank you for that. Representative Weichel.
Did you have one?
Yeah, I did. So, yeah, and again, these glasses really screw me up. I apologize. So I guess what I'm hearing, Mr. Chair, is I think I'm more inclined to align myself with Representative Blex as opposed to the alignment on the amendment. Thank you, Mr. Chair.
Representative Weichel.
Thank you, Mr. Chair. To address Representative Blex, I mean, it wasn't my understanding that Section 1 was included to address false accusations. I feel like that can be addressed through other amendments and other part of the legislation. This is really, and presumably through investigations through the Board of Nursing, this is really to ensure that whatever we are voiding, and let's remember we're voiding it permanently, is not a violation of the Practice Act that has implications for patient safety. And I'll also say I've spent a lot of time in the past week talking with folks. I reached out to KU Med and I asked their attorneys to look at this. I reached out to the Hospital Association. I reached out to my local hospital, all people who employ a lot of nurses. They were extremely concerned about the language as it was written in the original bill. And they've seen this language and they feel much more comfortable with this language.
Thank you. Committee, further discussion? Seeing. Representative Turner.
Thank you. So just trying to understand here. So that new Section 1 says any board action that arises from disciplinary action related to the statute. So it's not canceling the statutes, it's canceling the disciplinary actions. But I think elsewhere we're still going to hold on to those actions that weren't related to licensure issues. Isn't that correct? I mean, we're not wiping the slate clean. There are some valid if they were truly unprofessional behaviors.
Thank you, Mr. Chair. So the good lawyer answer is always, it depends. So in certain situations, under my interpretation of the bill as written, the language in paragraph 3 would not void an action where there were two, we'll just call them causes of action. If one is unprofessional conduct as defined in 651120A7, and then one is a separate violation unrelated to that, that unrelated one would stand. However, if the violation was unprofessional conduct in A7 tied to the definition of unprofessional conduct in the rules and regulations, which lists about 20 different things, including diverting medication, abusing a patient, and there was no other action listed, that would be voided.
All right, thank you.
Representative Weichel.
Thank you, Mr. Chairman. And just to, that was the conversation that Jen and I had when we sat down earlier this week. And if staff could help me hand out, I did bring copies of exactly what is listed under 112065, 1120A7. Is this okay to hand out? That these are things that would potentially not be voided under the bill as it stands.
Thank you. I wonder if the maker of the amendment would withdraw that amendment and the second until we find out if that's covered by other amendments. If it would not be, I can't do that. No, I'm just saying. Oh, I'm concerned that we may be passing this amendment and there may be other amendments that are going to take care of the same situation. Never mind. Representative Turner.
Well, I just wondered, since we're on the topic and we've got a handout, even if that action comes to pass, can I at least understand the position that the bringer of the amendment has in terms of what is and isn't canceled? I'd be interested in that, even if we come back to it later in the conversation. Thank you.
Thank you, Mr. Chairman, and thank you, Representative Turner, for the question. So, yes, so in my conversation with the reviser, it was clear to me that if the bill is not amended, anything on this list could potentially be voided permanently from the records because it falls under 65-1120A7, which is listed on line 23 of the bill. And there are other, this was kind of the most worrisome citation there, which is why I asked for the clarifying language to it only apply to the clerical errors to apply to everything that's listed.
Thank you for that. Representative Blex.
And you may have answered my question, but so your amendment would not allow these to be voided, or would it be voided? These could be avoided on what you're doing, because you're limited just to the license issue, correct?
These things on, Mr. Chair, if I may, under my amendment, the things on my handout could not be voided.
Thank you.
Committee further discussion. Representative McDonald and then Berquist.
Thank you, Mr. Chair. I guess that my question might be for Jenna. Should we not amend this? And should this list, long list of items that Representative Weichel gave us go into effect so that people who have done some of these pretty terrible things are absolved of it from a licensing standpoint? Some of the people who did these things would be in prison right now. What would happen to their sentences if this was suddenly expunged? I don't know if expunged is the word, but I think this is just a whole can of worms if we don't fix this bill.
Okay, well, I can't tell you whether you should or should not amend it. That is up to you all to decide. The last question, if there was a criminal charge tied to one of these, that would stay. However, if charges have not been brought and these records are destroyed, that may affect, a prosecution. Because avoiding means the records are gone. They can't come back if you needed them for a later charge. Or if charges wanted to be brought later, there might be a statute of limitations issue depending on how long ago this was. And then I'm going to try to explain this, and I hope it makes sense. So The regulation that was handed out is the definition of unprofessional conduct from the rules and regulations, 63-110. That is part of the list in B related to W, which is practicing without a license. So that one, if the discipline was practicing without a license pursuant to this reg 63-110W, that could be voided. However, when the Board of Nursing creates these disciplinary actions, they have to cite a statute, not just a regulation, is my understanding, in order to revoke a license. So when you cite the statute, a very common statute to cite would be violation of unprofessional conduct, that's 65-1120A7. And then you would go on to explain in the disciplinary action, this is for a violation of one of the things listed in the unprofessional conduct. So I hope that makes sense.
Representative Berquist.
I'm trying to wrap my head around it too, but my concern is the amount of administrative carelessness, in my opinion, and listening to and being in these hearings that took place in some of the accusations that were made here that were left long-term to be unresolved. You know, if any of those were unresolved, that they could be left hanging in limbo. I don't want to hang anybody in limbo that was abused in the process of having a speedy trial, so to speak, within the system. And I see all these things, and I just don't want to throw a blanket back on the damages that were done to these nurses and these APRNs and the whole works by putting another damper back on it if it's not the right thing. So I'm just trying to listen. I'm just letting you know that I'm concerned in that way. I might have a hard time voting for the amendment. So.
Representative Blex.
Thank you, Mr. Chair, and the reviser answered some of my question, because it looks like, you know, W is an issue. If you void that, you know, where you're practicing without a license and you didn't get a license because of their problems, then that couldn't be voided according to what you convey to me, or it can be.
Jenna.
Thank you, Mr. Chair. That would be an action related to license or license renewal.
Okay, so then
So that
everything
would be
on,
voided.
everything on this sheet is not what maybe I understood, because
Yeah.
I understood the statement that everything on this sheet could not be
Well,
voided. Maybe
the-
I misunderstood that.
The ones that are unrelated to license or license renewal. So if you're renewing late or you renew as the wrong type, some of the issues that we heard about in the committee, those would be allowed to be voided. But the ones related more to the practice of nursing that maybe were unintentionally, you know,
Okay. All right.
brought into this would
All right,
not be
thank
allowed
you.
to be voided.
I know how I'm voting.
Thank you. Representative Bueller.
Thank you, Mr. Chair. And it seems to me that the more we auger in, the more and more confused we get. So if I pull back up to a higher level, my understanding is that with House Bill 2528, before the amendments from Representative Weichel, that these acts would not be voided in the language. And I think that's for, I don't know if that's a direct question back to the revisers, but that's the way I'm interpreting it. And I don't know if we're at a point where we just call the question and vote on the amendment.
Not yet.
Okay. I'm
Representative
just
Stevens.
trying to figure out where I am on this one. Thank you, Mr. Chair.
Thank you, Mr. Chair. So Jenna, I'm trying to grapple this too, because my understanding is with this statute, okay, and I've been listening to everyone, I've been trying to figure this out so I understand it myself. If this statute, like under this particular one, since it's a statute and unprofessional conduct includes all of these items, okay, as Representative Weichel was saying, that the statute itself really isn't existing anymore then? I mean, would you have to wipe out the whole statute because of all these things that are listed? I guess I'm just can you void one line? Like take out the CE? I'm just trying to understand.
So this would not void the statute. The statute would stay in place. It's being amended later on in the bill, but it's the disciplinary actions arising from a violation of that statute would be voided. And so because definition of unprofessional conduct is defined in the rules and regulations, it encompasses everything that is in the rules and regulations definition of unprofessional conduct. So the statute says unprofessional conduct as further defined by rules and regulations of the board. So if your disciplinary action says you had unprofessional conduct, anything mentioned in the regulation would go along with that because that's the definition. So those would all be voided, unless there was separate action with different statutes cited, essentially.
And I just might add, we were all concerned about that. That was one of the major things that we were concerned about when we heard this bill was that how to separate those two out. So I think this is an attempt to do that. Representative, I'm not going to put words in your mouth, but I think this is an attempt to do that. And so, Representative Ruiz.
Okay, take a stab at it. Without the amendment, now this is to our advisor, without the amendment, the way the statute reads, the way the bill reads currently, these are all of the violations. Everything gets voided according to the bill except W. Oh, you're right, yeah, W, everything in here is voided. With the amendment, the only thing that is voided is W on here, which is practicing without a license or while the license has lapsed. Because it relates to the applications of licensure or license renewal.
Yeah, that's my understanding, unless there's something else in that definition that talks about license renewal.
Thank you. Yeah, because that's where the concern is that without the amendment, everything listed on these 2 pages gets voided. The amendment clarifies that and only takes out that one section regarding the licensure or license renewal.
Thank you, Mr. Chair. Representative, that's my understanding.
Thank you.
Representative McDonald.
Thank you, Mr. Chair. I'm really grateful for our staff and for our attorneys today because this is a little convoluted. But my understanding, if we don't pass this amendment, we're putting employers in a position of not knowing the background of the people they're trying to hire. And I think that that's really an unacceptable thing for us to put upon people, especially our employers, especially for something as important as healthcare. So I'll be supporting this amendment.
Thank you for that. Seeing no representative, you may move your amendment.
Thank you, Mr. Chairman, and I appreciate the discussion today. I'll just reiterate that I've had a lot of conversations over the past week with different folks on this. The revisers, I spoke with Representative Pickert this morning. I've spoken with, like I said, the Hospital Association and KU Med, my local hospital. Everyone I've spoken to is supportive of this clarifying language, and the intent really is to make sure that what we're voiding permanently is clerical errors related to the licensure renewal process, and that we're not inadvertently voiding really dangerous things that could have implications for patient safety. And so I would really ask the committee to support this amendment. And with that, I move my amendment.
All right. You've heard the motion. All in favor, say aye. Oh. Aye. Opposed, same sign? No. The ayes have it. Motion approved. Back on the bill. Representative Ellis.
Thank you, Mr. Chairman. I have a motion, amendment, and if the kind lady would pass this out. It is on page 19.
Do you have a second?
Oh,
I'll second.
Second by Representative McDonald.
sorry.
Continue.
Okay. It's on page 19, lines 37 and 38. Page 19, line 37, 38 states, "A member shall not serve on the board while elected to the office of governor or attorney general or a member of the legislature. That would be crossed out. I believe this isn't part of the main genesis of the bill. So,
Thank you for that. Discussion committee on the amendment. Representative McDonald.
Thank you, Mr. Chair. I think a lot of us serve on boards, and myself included, a lot of legislators, and I think there's a real place for that. We bring a certain expertise and also a bit of perspective. So I also had this amendment drawn up, so I'm glad that you brought it forward, and I fully support it.
Further discussion on the amendment? Seeing none, you may move your amendment.
I move my amendment.
All in favor, say aye. Aye. Opposed, same sign. Amendment carries. Back on the bill. Representative McDonald.
I've also got an amendment. Sorry, I thought I pushed the button. Thank you, Mr. Chair. I've also got an amendment that if the revisers could pass out, it's the second page is page 11, and it's got the word licensure and a couple bubbles. Long story short, there's a little tightening up of the language. I'll let them pass it out, and then I'll explain it to you. I think it'll make it a little easier to implement.
Do I have a second for the amendment? Second by Representative Weichel. Can you explain your amendment while it's being passed out?
Happy to, thank you. On page 11 of the bill, towards the bottom, on line 37, it says, under proceedings, upon filing of a sworn complaint with the board charging a person with violating any of the practices specified in the subsection, 2 or more members of the board, one of whom shall be a nurse with similar, and I'm just inserting the word licensure, with similar clinical or professional experience to the person charged with a violation. Adding the word licensure just broadens it a little bit more and makes it easier to implement, I think. And additionally, it adds the word licensure before, on line 43, before clinical or professional experience. And then in addition, on page 12, there are just 3 little bubbles there. On page 12, line 9, instead of giving one year, any investigation of a licensee or applicant should be considered closed after 1 calendar year. I'm proposing 3 calendar years. There could be situations in which licensees might try to stall an investigation, and so 3 years gives us more time to do all of this investigation and such. And then on line 12, I added unless proceedings have, so it would read, any investigation of a licensee or applicant shall be considered closed after 3 calendar years from the date that the board is first made aware of any licensees or applicants' alleged violation of the Nurse Practitioner Act or rules and regulations adopted pursuant to that act, unless proceedings have been filed against the licensee or applicant, or the licensee has entered into a consent agreement or diversion program. And at that point, my last suggestion is to add or delays have not been caused by the licensee. This just really deals with making sure we have plenty of time.
Jenna, is that accurate, an accurate description of what this amendment does?
Yes, Mr. Chair, I believe so.
Thank you. Committee discussion. Representative Blex.
All right, Representative, I don't really have too much problem with much of it except 3 years. 3 years is just one heck of a lot of time to put your life on hold one way or the other. In the world of electronic, if you can push a button, you should be able to get things a whole lot quicker than, that's just ridiculously too long. I'll be against that for 3 years. 1 year was, I think, appropriate, but that 3 years is just way too long to bring somebody's life. They're in limbo. They don't know what they're going to do.
Representative McDonald.
I appreciate the chance to respond, and I do appreciate your point here. I think one thing we often forget when we put more things upon agencies of the state, we are not always investing in software. A lot of times they're playing catch up. We just are right now putting a whole lot of more paperwork and administrative burden on them with this bill, and I think perhaps we could look at it again after a year or two and see if that 3 calendar years is too much. But I'm really afraid that we might be asking the impossible of some people and not allowing enough time for due process to happen. But I am sympathetic and sensitive to your concern there, and I appreciate that you like the rest of them.
Well, this committee asked impossible of me to have it be gone yesterday and turn around and drive 3 hours to come back up here, but here I am. So it can be done. Thank you.
Representative Reeves.
Thank you, Mr. Chair. I was going to just saying why I'm going to support this particular amendment. One of the things is it's not just upon the licensee to bring forward information regarding an investigation. It's also on the other side. And the other side could be an agency, it could be whoever, is making the alleged violation they can also stall too. So it's not just the licensee that might stall, it's the other side too that would stall. And I believe that according to the Board of Healing Arts, they recommended the 3 years and not the 1 year. And the piece that I really like the most is the third edition. It says, or delays that have not been caused by the licensee, because it's not always the licensee who's causing the delay. It could be on the other side. And I would hate to see an investigation just be rushed and the licensee not really have the enough time to really present their case. And it doesn't mean that it's going to take up to 3 years. It could be less. It could be even less than a year.
Representative Weichel.
Thank you, Mr. Chairman. I have a question for staff on the 3-year. I don't know if they'll know the answer. I was just wondering, like, how that aligns or doesn't align with other boards, like the Board of Healing Arts or the Board of Pharmacy or whatever it may be.
Thank you, Mr. Chair. I'll have to look into it further, but I don't believe that there are other time-limited actions when it comes to these administrative actions for other health professions.
Thank you. Representative Bueller.
Thank you, Mr. Chair. And I, too, will be opposing the amendments. I have an amendment that might help us get a little closer. But when I look at this, I see the word licensure, where it's inserted several places, feels limiting to me, and I do not agree with the 3 calendar year provision either. So for that reason, I will not support this amendment, but I do have one when it gets to my turn. Thank you, Mr. Chair.
Representative McDonald.
Representative Bueller, thank you, Mr. Chair. Representative Bueller, it's not the word licensure, is just being inserted in addition to clinical or professional. So a nurse with similar licensure, comma, clinical or professional experience. So I don't see that it limits more. I feel like it makes it a little more practical to do.
Representative Berquist.
The 3 years is very troublesome to me. Someone who's working to have a career that actually helps people and to have them on hold for as much as 3 years, no.
Thank you. Committee, further discussion. Representative Steens.
Thank you, Mr. Chair. Well, and my question would also be, from my understanding, and correct me if I'm wrong, a nurse can still practice under some, depending on what that conduct is or what they've been charged with, only because I've known nurses that have been charged with some, depending on what that violation may be. And we had heard in testimony here, I apologize, I don't remember the young woman's name, but she said she had called and it took them like 4 or 5 years and they still hadn't gotten a call, and it was a very serious violation. So I think, yeah, it just seems like we're still letting that, and she was like, then this nurse is still practicing, and it was a very serious infraction. So, yeah, I would not be able to support this amendment. Thank you.
Committee, further discussion. Seeing none, Representative McDonald, you may move your amendment.
I move my amendment.
You've heard the motion. All in favor say aye. Aye. Opposed, same sign. No. Motion fails. Back on the bill. Representative Bueller.
Thank you, Mr. Chair. I have an amendment. I hope Carly and Jenna have it. And I appreciate that is it. So wait till it's passed out.
Do you have a second on the amendment? Second by Representative Steens? Representative, would you like to explain your amendment while it's being passed out?
I will, Mr. Chair. I know, so just kind of working through and hearing some of the conversation, went through and just made some, in some cases, some grammatical changes, and just tried to tighten some of the language up. So, for example, on page 1, line 19, strike the words related to and then add based upon a violation of. If you go down to then page 1, line 30, where it says related, I think that's where I am. That's same language on, let's see, line 23, adding in the appropriate statutes, and that's, you'll see that kind of consistent. You get down to line 30, again, striking the word related to based upon a violation of. Page 34, the same thing. You get to page 2. I'm trying to put my notes together with what the revisers just handed out to make sure we're consistent. I get to page 2, line 9, strike the words after being provided notice, striking that in line 9. Page 3. I'm going. Page 4, 1 day, changing the, where it says verify the accuracy of the application and grant a renewal license within 1 day. Add 4 days, so make it 5 business days. Go down to where between line 29 and line 30, add a license shall remain valid and active during the 90-day period following the renewal date. Also at that time frame, there are several stipulations, or where it says a license is canceled for failure to renew, approval of the board, et cetera, et cetera. And then, if you go to page 11, in terms of proceedings, get down to line 41, you'll see except as provided in this paragraph, there's some language in there. Page 12, you'll see insert an alleged violation that is not related to nor arising from the practice of nursing, which may be investigated by a board member or a designee without such similar clinical or professional experience. You go down to line 8 and see where it's inserted C. The other one is any investigation shall be closed after, I think it's 22 months. Page 15, again, we have the, instead of 1 business day, it's consistent to go to 5 business days. And then line 22 on page 18, license shall remain valid and active during the 90-day period following the renewal date. And then there's renumbering that the revisers have added that would happen accordingly. And then finally, on the last page, which strikes lines 37 and 38, which we just had an amendment on that. And that is the amendment.
Thank you for that. Committee discussion on the amendment. Representative Weichel.
Thank you, Mr. Chairman. Given that it's a pretty comprehensive amendment, I'm not sure what the appropriate question here is, but essentially my question is, can we divide this amendment into different sections?
That would be up to the maker of the amendment.
So we can
In
discuss.
the second.
I guess I've never had to do that, so I'm kind of asking for some either guidance or thoughts from Jenna on this one. So is it just clarity that you're asking for, or?
So just like, for example, the changes in section 1, we've already amended section 1, so I think that warrants a discussion, but I'm not sure my comments on section 1 would pertain to my comments for your amendment as a whole. So like, if we could divide it in pieces, so it's not all yes or no, but we can talk about the different pieces that aren't necessarily connected.
I'm not following that, but I guess what I'm open to is if between Jenna and Carly, if there's an interpretation of those changes, if that would be helpful for the committee, I'm amenable to that, other than me just reading them if there's.
It would be up to the will of the committee and the maker of the motion if it wanted to be split. If there are questions beforehand that maybe would provide clarification, that is an option as well to do that, and then decide if you want to try and split it into two parts or whatever the will is.
At the risk of sounding insensitive, I'm really not wanting to try to divide and split and conquer. I think I'd like to leave the motion as is and go from there and have discussion, vote it up or down.
Very good. Thank you for that. Representative Turner.
Thank you, Mr. Chair. Just to clarify kind of what we're talking about. So was the request for purposes of discussion divided up so that we're not jumping from page 1 to page 18? Is that what's been moved as far as, we could probably, I would agree, it'd be nice if we could discuss it in somewhat of an order. And then if there's disagreement, I guess we could discuss whether it needs to be physically broken. But for discussion, I would agree. I'd be on board. Thank you.
Hang on. Representative Blex.
Thank you. Again, Representative Bueller, you changed from 1 calendar year to 22 months. Is that, what was your reasoning there? You just feel like there wasn't enough time? Because here we just groused about 3 years. And
I believe that's consistent with other cases. It's not just some random number. And it's certainly less than 3 years.
Okay, thank you.
Representative McDonald.
Thank you, Mr. Chair. I was just going back to page 1. I noticed, I'm just trying to understand what you're trying to do on page 1. We've got a lot of inserts here relating to certain statutes and prior to this day and prior to that day. Can you just like broadly tell me what we're doing in the second half of the page on page 1?
Yeah, I
Jana?
think.
Thank you, Mr. Chair. So what happened in 2019 is that there was an additional subsection added to that statute, so to cover the right time period for the intended violations. So I believe it would be unprofessional conduct was in A6 before July 1, 2019, and then after that, it's in A7. And so this just makes sure that despite the changes to the statute and the regulation, that the right time periods for those would be covered appropriately. And then the other ones are just changing related to based upon a violation of.
Committee, if it would be helpful, Jenna, would you be amenable to go through these amendments at one time? Maybe that would, and then write down your questions for which part of that amendment you did, what page and the line numbers and stuff, and that way we can maybe knock down some dominoes of concern on that way, if that would be okay. Okay. So
Okay.
let's just start at the top, based
Yep.
on a violation.
Thank you, Mr. Chair. So on section 1, in page 1, it would change the uses of disciplinary action related to based upon a violation of. And then that would be, 3 times on that page. And then there's the 2 instances where the statute and regulation was amended, and so it would just catch the right time period for that action, so we're not referring to the wrong one. On page 2, it strikes in line 9. This is the subsection about the board, if a board has previously provided voided material to another person or entity, the bill as written would require the board after notice to tell that other entity, that outside entity who has that information about being voided, and this would strike notice. So the board would just have to, on its own, notify the person or entity that the agency action has been reversed and to delete essentially that material. Let's see, the next changes would be on page 4. This is section 2, which is license renewal for RNs and LPNs. The initial language of the bill would give the board 1 day to issue a license after submitting your application, and this would change it to 5 business days. Would also insert a provision that a license would remain valid during that 90-day grace period following what is being called a renewal date, which was formerly the expiration date of a license. It also adds new language about license reinstatement. When the bill was being drafted, reinstatement was changed to late renewal. And so this puts back in the option for a license to be reinstated, and it is copying the language from the Board of Healing Arts in their statutes about having a license reinstated after it has been lapsed and not renewed. See, the next changes are on page 11, which would be section 5, I believe. And it would create, sorry, so this would be on pages, 11 and 12. And it would add that an alleged violation, this goes into who can investigate violations. The initial language of the bill would require it to be a nurse with similar clinical or professional experience. And I add language, except as provided in this paragraph. And at the end of the paragraph, it says that an alleged violation that's not related to essentially the practice of nursing could be investigated by someone who didn't have similar clinical or professional experience. So if it's something unrelated to nursing, I don't know, maybe some outside criminal activity, you wouldn't have to have a nurse with that same experience investigating that. Would also extend the time period that the board would have to wrap up an investigation from 1 calendar year to 22 months after being made aware of that violation. And then the changes on 15 and 18 are the same licensure renewal provisions for APRNs that were done to RNs. So allowing the board 5 business days to grant or not grant an application, and then adding in that a license would remain valid and active during that 90-day grace period. Oh, sorry, 19 was dealt with in another amendment, so it's duplicative.
Very good. Representative Weichel.
Thank you, Mr. Chairman. I have a question for staff. So we've already amended section 1. If this amendment is adopted, does the previous amendment the committee adopted still remain?
Thank you, Mr. Chair. In this instance, yes, it's not a direct conflict, and so we are able to interpret these together, and we'll just put them as one. If it were a direct conflict, you know, if you had stricken one statute and then another amendment added that statute back in, then that would be a direct conflict, and we would take the one later in time. But these don't conflict, so they can be both voted on and still fine.
Thank you.
Okay,
And that's part of the reason why I wanted you to pull your amendment, so we could do this and not have any duplicative amendments. Committee, further discussion on the amendments? Representative Bueller, you may move your amendment.
Thank you, Mr. Chair. I move my amendment.
You've heard the motion. All in favor, say aye. Aye. Opposed, same sign. Motion carries. Back on the bill. Committee, are there any more amendments out there? Representative Ruiz.
Thank you, Mr. Chair. I have an amendment. Let me think. See if I can get the right one. Oh, is this? The amendment is just adding on page 22 upon request. Yeah.
Do I have a second on the amendment? Second by Representative Opeza. Representative, will you explain your amendment while it's being passed out?
Yes, Mr. Chair. Let me look. Okay, so page 2, it's line 17B. We just add, upon request, the Board of Nursing shall issue a refund from the Board of Nursing Fee Fund to an applicant or licensee under reasonable circumstances, including an overpayment or duplicate payment made by such applicant or licensee. something needs to trigger that, and it just felt like to me that as the licensee, I would be the one to trigger that. So it'd be upon request.
Committee discussion on the amendment. Seeing none, Representative, you may move your amendment. Oh, Representative Turner, sorry.
Thank you. The question would be, does this, it seems to take it from they shall issue a refund to qualifying it only upon request now. It seems less stringent than the original. Is that your intent?
Well, it's not that it needs to be stringent, it just needs, somebody needs to move on it. And so if we're going to wait for the board to move on it first, it just feels to me that if I was the nurse, I would be the one requesting it. And if I request it, then the Board of Nursing shall issue a refund.
Representative Turner, there is the word shall in there, which doesn't give them any leeway at all, at least from.
Right. And we don't want, she's not, I'm sorry, I don't have my mic. Yes, and that's what I'm asking. Your intent isn't to take away the shall, but it seems to be doing that by putting upon request, they shall.
Yes, I don't see it, I don't hear it that way.
Jenna?
Thank you, Mr. Chair. I interpret it as just giving them notice. If you accidentally process a double payment, the Board of Nursing might not realize that. It's just through their licensure renewal system, so you just have to let them know, hey, I want my money back. It would, the shall is still there, so you just have to ask for it.
Thanks for the clarification.
Representative Weichel. Committee, further discussion on the long amendment that Representative Ruiz has. Seeing none. All in favor, say aye.
Aye.
Opposed, same sign. Amendment is passed. Back on the bill. Representative McDonald.
Thank you, Mr. Chair. I just have one more tiny little amendment for the revisers. The back page says the preponderance of the, in a bubble. Basically, on page 22, line 30, it says, if such violation is proven by clear and convincing evidence. And I think clear and convincing sounds somewhat subjective. I felt like the words, the preponderance of, so it would be, if such violation is proven by the preponderance of the evidence, that would be a better, more clear and straightforward way to say what we're trying to say. To me, clear and convincing evidence is a little more, like from a quantity of evidence, you're thinking small, but with the preponderance of the evidence, you take all of the evidence into account.
Thank you for that. Do you have a second for that amendment? Representative Orpeza seconds. Jenna, would you explain to us the difference between clear and convincing and preponderance?
Thank you, Mr. Chair. So there are essentially 3 different levels of proof in our judicial system. We've all heard of beyond reasonable doubt, that's criminal. Preponderance of the evidence would be your standard burden of proof in a civil action. So if you have a medical malpractice case or a car accident, who's at fault, the typical standard of proof would be preponderance of the evidence, which means basically more likely than not. And then there is a intermediate standard, which is a clear and convincing evidence. There's not a great statutory definition, but essentially means somewhere in between the two. Less than beyond reasonable doubt, more than, more likely than not. There's a couple instances that we use it in statute. The most common one would be like taking a sink action, taking away parental rights, or terminating parental rights would be, you'd have to prove it by clear and convincing evidence. But for most civil things, it's preponderance of the evidence.
Thank you for that. Committee discussion. Representative Steens.
Thank you, Mr. Chair. So just so I understand that correctly, you're saying that preponderance is a lower standard than clear and convincing?
Correct.
Committee further discussion. Seeing none, Representative, you may move your amendment?
Thank you, Mr. Chair. I move my amendment.
You've heard the motion. All in favor, say aye. Aye. Opposed, same sign? No. Amendment fails. Back on the bill. Committee, further amendment? Further amendments, anyone? Oh, wow. I'm Representative Bueller.
Thank you, Mr. Chair. I move that we pass out House Bill 2528 favorably as amended.
I have a motion, second by Representative Howell. All in favor, say aye. Aye. Opposed, same sign?
Discussion.
Oh, sorry. Is there discussion, committee? Representative Weichel.
Thank you, Mr. Chairman. Sorry to hold everyone here a little bit longer. No, I think the work today improved this bill quite a bit, and especially when it comes to being confident around patient safety. I do think there's still one unanswered question that I haven't been able to get clarity on, and that is whether this bill in any way impacts our compact license. And I reached out to the chamber this week about it, and I haven't heard a definitive answer. So I guess I would just like to name that and say I think we should try to get some clarification on that before next week.
Thank you for that. I too have heard the same thing, and I have not gotten any information back on how it affects our compacts. And at this point in time, I'm not aware. Representative Blex.
Thank you, Mr. Chair. I appreciate the discussion here, and this has been an enduring thing, and I think with the amount of contacts each of us gotten, and there was some really serious things that impacted people's lives. And in saying that, I think we need to send a serious message that it needs to be changed. And to some degree, to some of us, that may not be enough, and others, it may go too far. But the bottom line of it is and I think all boards should support the profession they're in. They should spank those that need spanking. But I see a real lack of things that, maybe not, they don't really support the profession as well as they are, and particularly in healthcare where there's such a shortage. And, I think that we have sent a message, we have brought attention and some clarity. There's a lot of questions, but yet I think it's been a good, and we've seen a lot of, I've seen a lot of articles in newspapers that have alerted to a lot of people beyond this committee about what's going on. We had an article in our local paper, and I've got a lot of questions already. And so I think the word's out, at least, that we're trying to correct something there. And I appreciate the hard work of the committee and all the efforts. It's been really complex. There's a lot of things. And when you start hurting people's lives, you really get passionate, and it is tough. So thank you, Mr. Chair.
Committee, further discussion. Representative McDonald.
Thank you, Mr. Chair. I also appreciate the conversations we've had. I appreciate the emotion, and people's livelihoods, are at stake. So my no vote today is not trying to dismiss any of that. But I think that this is a really, really broad bill that, as you can see, has many, many parts. I am not convinced that I think there would be some unintended consequences if this bill passed, even as amended. So at this point, I'm a no, but I do really appreciate the good faith effort people have come to sit down and try to find some compromises and work out some of those unintended consequences. But I still am at a no at this point. Thank you.
Representative Reeves.
Thank you, Mr. Chair. I have been straightforward, honest, and transparent with everyone that has come to my office to speak to me, even for the folks that came and found me last night when they came out of a committee. And I have been pretty adamant about my stance on not supporting this bill, and as to why. I've been extremely supportive of nurses, and you can check my voting history to know that. But for me, this does not touch upon the elephant in the room, and that is the board, and now I'm not talking about the members of the board, but the operation manual, the rules, regulations, whatever it might be that the board is operating from, it does not impact that. So it doesn't matter who else might come onto the board, they still are going to operate out of the same manual. And so this just doesn't do that. It doesn't fix that. And this is barely a Band-Aid. And I really wish that more time was devoted to that, like a real, true task force. You can just see in the bill, just on the first page, lines 21 through 28 alone lists, I don't know how many statutes. And my understanding is that the board is operating out of regulations and statutes that are at least 40 years old, and nothing has been done to try to update anything. That would be a great job of a task force that we have seen other task force that the legislature has put together that's done great work and truly tried to get down to the meat of things. I just don't, it's not going to change that. I'm sad that it's not going to really change that. So at this time, and the issue with the compact, we don't have any answers about what it'll affect the compact. So for that reason, I won't be supporting this bill. Thank you, Mr. Chair.
Thank you, Representative. Representative Steens.
Thank you, Mr. Chair. First, I just want to start by thanking everyone that's been a part of these hearings that we heard last week. I know it takes a lot of courage to come up and, you know, as a nurse, you get into this because you want to care for people. And I heard a lot of nurses out there that felt very much, you know, targeted, I guess, for lack of a better word. I don't know if that's the word I want to use. I don't think that was the intent of the board, so I want to make that quite clear. I don't think anybody was out to get anyone. I just think that there were definitely lots of clerical errors and then the unprofessional conduct and everything that encompassed. But I know Representative Pickert and many others did a lot of work on this bill. I know they met for months and months. Is it perfect? I mean, yeah, there may be some questions I think that still need to be allayed and here and there, but and I don't know how perfect a bill you can get for this. I know a lot of times up here we don't always probably get to discuss things as much as we'd like them, but on the flip side of that, we also have to think about protecting people, and it just seems like there were those that really suffered some very strong consequences that affected their lives and are still on their records. I do want to just thank, though, all the people that came to me. I want to listen, I want to understand, and I do my best to really study these things. And so I just want to appreciate everyone on this committee and the Oversight Committee and all those that did so much work to try to make something a good piece of legislation in the best way that we could. So thank you.
Representative Berquist.
Thank you, sir. I'll try to be brief. The work that's been done by this committee and the leadership in response and when it's been brought to light, all the problems that have been brought to light as far as the management of professional nurses and licensed practical nurses and the type of things that we're addressing today. I'm proud that as this does pass out of this committee today, that it is a starting point and not a finishing point. And I appreciate Representative Reese's comments about that it doesn't address some of the elephant in the room. The elephant in the room is still there, and we're still here, and we still have responsibility to move forward. So I hope to be a part of continuing to address these things, but I think this is something to proudly bring to our body as a whole, and to rally behind this with our vote. And I thank you very much.
Representative Buehler.
Thank you, Mr. Chair. I wasn't going to speak, but one of my colleagues who's thinking the opposite way than I am, I don't believe that a committee studying the statutes would make a lick of difference in this case. if this has been going on since 2005 in some cases, it clearly shows to me that the board leadership of the Kent State Board of Nursing is clearly disconnected from the discipline process. That stands out over and over again. The board has the responsibility to audit the effectiveness of their own policies. We can try to mandate stuff, but if they're not engaged in this, this will never change. I think in my experience is 28 years in the Navy, when something like this happens, if you're the commander of this ship, you'd be relieved for command for this kind of stuff. So it's not necessarily designed to be punitive, but it is designed to say enough's enough. We've got legislation here that's fair, that will fix this going forward, and we need to give it a chance. Thank you, Mr. Chair.
Committee further discussion? I too would like to thank everybody that worked on this. I know it started in the summer and it's still going on at this day. And one of the things that I'll tell you as I first came to the legislature is it's a character flaw, but I look for silver bullets, something that's going to fix everything. I very quickly learned that that was not the case, that these documents, in fact, are living documents. And one of the other things that I say about this, and I'm not saying that in this case, but I'm saying by the time the ink is dry on a bill, there are people trying to figure out how to get around it. And that's the fact. So it's not done. It's a step forward. And I also think this has been going on for a long time. And to ignore those facts and to bring it to the volume of people and things that we have seen here is unexplainable to me, because it takes a lot of things to go wrong for it to become the item that has become here before us now that the legislature has totally gotten involved in it. It takes a lot for that to work its way into this much of a situation. And so we'll be watching, and let's just hope folks figure it out. With that, committee, have we already voted?
No. That's next.
Okay. With that, all in favor say aye. Aye. Opposed, same sign.
No.
Who would like their no vote? The motion passes. Who would like their no votes recorded? Representative Orpezo would like her no vote recorded. Anyone else? Very good. Thank you for that. Committee, we will take about a 5-minute break, and I mean a 5-minute break when I say that, because how long it takes on this next bill will be the difference between you getting home on Friday night or not. So you need to figure it out. The 2366, I'd make a motion to start working 2366. Do I have a second? Second by Representative Bryce. Committee, are there amendments? Oh, no, here. No, go ahead. You're going to explain. Sorry, I skipped. Carly, will you explain what 2366 does?
Thank you, Mr. Chair. House Bill 2366 relates to the practice of naturopathy, licensure and regulation of naturopathic doctors, and it broadens the scope of practice for naturopathic doctors.
Thank you for that. Committee, questions? Representative Bryce.
Thank you, Mr. Chair. I have an amendment.
Is there a second? Second by Representative Turner. Would you go ahead and explain your amendment while you're passing it out?
Yes, it would be helpful for people to have it available, but let me start by, okay, can we, is it okay to wait?
Yeah.
Okay. Okay, the amendment has four or five, I would say 4 or 5 items to talk about. Just a background on the amendment. There was the original bill, I for one and some others had some problems with some of the things in the bill as far as transitioning from scope of practice from naturopathy to basically diagnosis, prescription procedures as in medical practice. And so there were some back and forth discussions between the medical doctors, naturopathists, some of the representatives of each party, and also the Board of Healing Arts. First box says non-invasive on page 1, line 10. That's deceptively small. We originally wanted to, if you remember the hearing, we wanted to better define what surgery was and what anesthesia was. That became problematic. The proponents of naturopathy would not agree to the definitions, and so it was felt that rather than trying to push through something that was not going to be easily swallowed, we would have non-invasive and let the Board of Healing Arts kind of work out the definition of surgery and anesthesia, so it would be kind of consistent across multiple disciplines. And so what this means is a naturopathic doctor may order and perform non-invasive physical examinations, and it lists some of the things excluding basically scopes and things like that. The second part would be, it's kind of interesting, line 27, intrauterine insemination. This is something that is allowed in the bill. I don't know how many people here are familiar with intrauterine insemination, but basically it's an instrumentation where it's not, forgive me, I have to describe things, but you put the instrument through the vagina. It's not inseminating in the vagina. It is putting the instrument through the vagina, through the cervix, into the intrauterine cavity and instilling sperm as a way of increasing the likelihood of pregnancy. There's about a 1% complication rate. Death is rare. But the point was it was an invasive procedure, so consistent with the previous line, non-invasive, we took intrauterine insemination out. Moving on, let's see, line 32, pursuant to a written protocol with a physician, prescriber, or administrator. That's a very interesting one. That's one that's been very confusing for people. If you recall, the APRN prescriptive authority, I forget what year it was, at least 20-something years ago or so, they initially had kind of a on-ramp of having collaboration with medical doctors. And as training and experience and education and time went on, they were able, with the help of Representative Blex and others here, were able to eventually have full prescriptive authority. This this amendment would have we've talked with the Board of Healing Arts Director, Susan Giles. The whole idea about it is a compromise that allows naturopaths to have prescriptive authority that they do not have now, with the idea of a stepwise or on-ramp where, as in APRNs and others, they eventually, as the whole structure is developed, will be able to prescribe independently. And so that was a compromise there. And then if you go to page 2, sorry, this is a fairly long amendment. Page 2, line 9, where it says perform labor. I think just to make that more clear, it's perform obstetrics, including labor. And let's say line 11, it says they shall not administer ionizing radiation for therapeutic purposes. And it says order or, in case ionizing radiation may not be a term that we use much, but it basically means X-ray therapy where you destroy tissue deep in the body by altering the DNA and destroying the cells. And it's fairly invasive, has a lot of morbidity associated with it. So it was felt that not only, the bill originally said not to administer, but this said also to not order or administer. And then in line, let's see, okay, then it was the abortion section, which is basically line 18. The original bill says perform procedures involving the cannot perform procedures involving the termination of a pregnancy. To be consistent with common practice now, it would be not only procedures of abortion, it would be drug-induced abortion. So what was added there, and I think in the hearing, Representative Berquist and others had mentioned that they wanted this, which would be basically no abortions, and take the political aspect of that out of it. And then moving on, I believe on page 21, if you look at line 30, instead of an approved medical college, it would be more appropriate to say an approved naturopathic medical college. And also, there's a little word, and naturopathic medical college that are not otherwise prohibited by this act and are approved by the board. Naturopathic medicine or naturopathic practice is currently under the Board of Healing Arts. And in order to be, right now, rules and regulations, they do, of course, comply with Board of Healing Arts. This would put in statute that the Board of Healing Arts basically can approve or disapprove in the future as kind of their oversight or umbrella oversight organization. Line 34, physician. Currently, naturopaths are not called physicians. They're called naturopathic doctors. And the idea is that when you're sick and you go to the doctor and the doctor says he or she is a physician, the common knowledge would be the person went to medical school and has a medical license to practice medicine. And so since that's not the case, we want to keep as is and not have the word physician. With that, Mr. Chair, I think that covers most of it, if there's any discussion. Thank you.
Thank you, Representative. So could you, just for my own understanding of words and things like that, define compromise?
I'll do my,
I mean, you've said, and your folks out there have said that this is a compromise bill. Is that accurate?
the amendment is a
that
negotiation.
accurate?
It's a negotiation.
Okay.
Yeah. I'd say
And how many of
negotiation.
these items were negotiated and actually compromised with by the other side?
Most of them.
Really?
For instance, I'll give you examples.
Let's start down through there then.
Okay.
Did they compromise on non-invasive?
Yes, sir. That's a compromise.
Did they agree to that term?
If I could, Mr. Chair, this
I'm
is.
just trying to get my arms around this. Did they agree to number 4, written protocol with a physician or prescriber administer? Did they agree to that? Was that a compromise? Was there any language? Did they agree to line 2? Did they agree to any of these, quite frankly? I think they did agree to the physicians and in the naturopathic. So I'm just saying, I think it's disingenuous when you say this is a compromise bill when the other party did not agree to it.
Mr. Chair, if I could, this is a compromise amendment because neither party agrees to it. It's one of these things, it's like Solomon and splitting the baby. The medical doctors do not agree with the vast majority of this.
So my amendments that you don't agree to, are those going to be compromise amendments that I have right here?
I'm not sure, Mr.
Well,
Chair.
I'm just saying.
I'm very sorry.
I
I
can't
don't,
call
I
those.
don't like the way this is going, and I will just respectfully, I'll respectfully be quiet. Thank you, sir.
Committee, questions about the compromise? Representative McDonald.
Thank you, Mr. Chair. I kind of am in agreement with you, sir, but I would like to ask a couple clarifying questions. On page 2, line 9, he's inserted, or you, sir, Vice Chair, Mr. Vice Chair, have inserted the word obstetrics. Do you have is there a legal definition that you were referring to, or is it more of a broad umbrella term?
Representative Bryce.
Yes, sir. I'm sorry. I think it's at its heart, it's a cleanup because the initial bill that was presented to us says they wouldn't perform labor. And so obstetrics would be to basically identify that, and I don't want to mischaracterize, but performing labor isn't a commonly understood term. So performing obstetrics would be more clear. Thank you.
Committee further discussion. Representative Reeves.
Thank you, Mr. Chair. I just want to make comments about the collaborative agreement. I'm calling it a collaborative agreement. That's the line 32-4, where it says pursuant to a written protocol with a physician prescribe or administer. So these collaborative agreements, and I've talked with some of the naturopathic doctors, and here's what I found out, that the vast majority of them are practice owners and small business owners, and because they are excluded from the Corporate Practice of Medicine Act, they cannot legally pay for a collaborative agreement. And so they would be forced to find a physician to provide the agreement for free. It's not going to happen. I mean, you're not going to find a physician that is willing to do that for free. So they'd be forced to close their practice to work for a physician-owned practice to implement the provisions. So I don't see where this is a compromise at all. I've not found one of them to say that they are in agreement with that. Thank you, Mr. Chair.
Thank you for that. Representative Blex.
Thank you, Mr. Chair, and I really hate to go against my favorite doctor in the room, but I will. Collaborative agreements are nothing but a cash cow for the physician. That's all it is. We paid $12,000 a year, so collaborative agreement physician could have a second house on Grand Lake. We signed come and visited, signed a protocol. This is what thou shalt must do, and you can't do this, which was rather broad. And you never saw him again unless you missed a check. You got a call. Now, having that for a referral, in case you got into a situation for an APRN, is a good thing, because you can pick up the phone and call if there's something. But that service is very much a free to area physicians that know very well that an APRN is going to, or somebody's going to refer them to their specialty. So I guess I have to be really, we went through this. Our goal of this committee has been, I've been up here 10 years, and we've been trying to expand accessible health care to the public, keeping the patients safe, and yet expanding that. And I won't use my favorite saying again there about how bad red the streets could get, but basically, a lot of that hasn't happened. We've been in 4 years since 22 of the APRNs out viewing this. I look at the naturopaths a lot. Similar to this, we have not had any issues. Liability insurance was way lower, the number of claims. 37 almost plus states are now doing it. VA was doing it before that. And it was, I think what this is an effort for control. This is my turf, and I'll let you do something as long as you work under me. And this is wrong. And like Representative Reese said, those people that are 1099 people, business owners that have employees, understand this big time, because they get a lower reimbursement from most insurance companies, about 85%, which is a physician gets. I don't have any problem with that. A physician is much better educated and has a lot more expertise. But at the same token, if you start dealing with more restrictions, like on the naturopathic doctors, to where they have to have a collaborative agreement, and it ain't going to be free unless it's in a joint practice where you're working as a group, that you may have a chiropractor, a physician, and a naturopath. It isn't free. There's no free lunch out there. It's cash. And believe you me, when you're operating a clinic and you're paying employees and you're operating 15% below what another person is getting, it's pretty tight. So I'm opposed 110% if you haven't figured that out to this amendment.
Any further? Any further? Oh, Representative Bryce? Sorry.
Thank you,
Didn't
Mr. Chair.
recognize you there.
Yeah, thank you, Mr. Chair. I'd hate to go against my favorite hunter and fisherman. But yeah, collaborative agreement, as he said, the physicians have the expertise, as the representative said. And so I can just speak from personal experience. I've been in many collaborative agreements. Some of them I was paid, I'm a physician, some of them I was paid, some of them I was not. I would review charts, I would help. This week, these were nurse practitioners. I would, MPAs. I would help them in kind of a mentor role. Some of them I would see maybe 10% of their charts and give them feedback. Others I would see 100% of their charts, give them feedback. And so what this part of the amendment is to have that same kind of, and I don't know if this is a good analogy, Representative, or not, but if you're, we had, in Fed and State this week, we had a airline or airplane license bill. And I was thinking, if you get your license to fly a plane and you just get on there by yourself, you know, something could go haywire. But if you have an expert, say a regular pilot, where like is required for the first, I don't know how many hours, then they can help you, guide you. And so that's the purpose of the collaborative agreement. There's nothing that is punitive or anything like that in my experience with it. So I appreciate you.
And so, in your experience, how long did it take the APRNs to get their collaborative agreements done away with?
I think the bill with Representative Blex did away with it in 2022. Yeah.
Representative Droege.
Thank you, Mr. Chairman. I have a little question of whether we're comparing naturopath to the APRN is a good example because of the training behind it, because of the different direction into medicine.
Thank you for that. Committee, further discussion. Representative Howell.
Thank you, Chair. I think the difference in the type of training and the different perspective between traditional medicine and naturopathic medicine actually is an important reason for why setting them up to where they're forced to work together in this kind of agreement, whether you want to call it a collaborative agreement or a written protocol, is problematic. Because there is a clear, for anyone with any understanding of the history of these two groups, there is a lack of respect between these two groups. And it is our job as legislators, when we're wearing our legislative hats, to represent the people of our districts. And the people of our districts want freedom to choose where they go for their health care, whether we agree with them or not. And so I think it is important for us to consider that as we make our choices.
Thank you very much for that. Representative McDonald.
Thank you, Mr. Chair. This is a question for Jenna. On page 21, line 32, the definition of physician is inserted here. I was wondering if that's like a standard definition in Kansas statute, or is that something new that comes about with this bill? Because Merriam-Webster says something different.
Yep. So physician definition is stricken in the bill, and then what's reinserted is our standard definition that's used throughout statutes.
Thank you.
Committee further discussion. Representative Turner.
Thank you. Thank you also to the bringer of the amendment. I mean, when we had the original hearing, I think there were concerns brought up about safety, and I've heard that, you know, our job is to speak for the people and give choice, but it's also to weigh that choice against safety concerns, or, you know, and the public doesn't have access. That's something that we are to weigh here when we make decisions. So I appreciate that. You know, we heard from the Board of Healing Arts and other folks that know this stuff, and so I appreciate that. You know, I was going to ask the question about physician, and I didn't hear the answer, because it looks like you're just reestablishing the stricken language. Is that correct? Okay. Thank you.
Committee further discussion. I am uncomfortable with this amendment. I think it kills the bill. I think it does away with all the intentions that, and that's why it was called a compromise, which it was not. And so, Representative, would you like to move your amendment?
I move my amendment.
I have two amendments, so we'll do the easy one first, okay? I think maybe we all might be agreement in this. My first amendment just puts the naturopaths in the healthcare stabilization fund, which I think we all agreed with and thought that that was a good idea. So that's my first amendment. That's not what we started the handout. That's okay. It's just easier to explain while the other one is pretty lengthy. Do I have a second on my amendment? Second by Representative Bueller. Carly, would you like to explain my easy amendment?
Thank you, Mr. Chair. This would add KSA 403401 as a new section 6, which are the definitions used in the Healthcare Stabilization Fund, and it would insert a new section. That should, a paragraph Y, not I apologize, and insert SEM or, it should read Y, licensed naturopathic doctor as defined in KSA 657202 and amendments thereto.
Committee discussion on the amendment. Seeing none, all in favor of the amendment, say aye. Aye. Opposed, same sign. Amendment carries. Back on the bill. Now, committee, you have the second amendment in front of you. Yep. And is there a second of the second amendment?
Second. I'll give you a second.
Second by Representative Steen. Committee, do you all have copies of the amendment? Okay, Carly, will you explain?
Thank you, Mr. Chair. In new section 1, it is a lot of reformatting, so to speak. But in line 10, it would read order and perform the following, and then start the list beginning with A, and that's existing language. And then the next change would be striking and in line 11, and inserting within the education and training of such naturopathic doctor, then it would continue on with laboratory examinations. Then in line 12, striking including but not limited to, and then the list would continue as written. Then in paragraph 3, the strikes would, where does it at? It broke it down further into a list, basically. So there'd be an E, an F, a G, and an H, and an I, but the language already exists within the bill. Then on page 2, it inserts obstetrics on line 9. So it would read perform obstetrics, comma, labor, comma, delivery. Then on page 21, in line 30, the language would then read treatments taught in any approved naturopathic medical college. Then on line 32, it would insert a new sub K, providing a definition for the term nutraceuticals and proliferative therapy. And then finally, in lines 34 and 35, would reinstate the definition of physician as it was previously in the statute.
Thank you for that. Committee questions? I have one does this prevent them from doing anything with abortions or providing abortions or anything like that?
This amendment does not deal with that language. The language as it currently stands in the bill would remain untouched.
And that keeps them from having anything to do with abortions?
Mr. Chair, no.
I thought there was an amendment. This was, okay, sorry. I'm getting ahead of myself. Okay. Thank you. Committee, questions on the amendment? Seeing none, I would move my amendment. All in favor say aye. Aye. Opposed, same sign. No. Motion carries. Back on the bill. Representative Blex.
Mr. Chair, I have amendment on malpractice insurance requirements.
Do I have a second?
Second.
Second by Representative Steens.
Give me a copy, Dave. Mr. Chair, while it's passing out, I'll explain this, if it's okay with you.
Sure.
Basically, I thought we talked a lot about patient safety. Anytime we get into new territory and explore something, and what this would do would, I think, give the patients a little more situation and requirement of carrying professional liability coverage shall be maintained in effect. That's on line 13, inserted there on page 25 on the back of the page that was handed out. And before rendering professional services within the state, each naturopathic doctor shall submit to the board evidence that such naturopathic doctor is maintaining professional liability insurance coverage of which the insurance liability is not less than $1 million per claim, subject to an annual aggregate of not less than $3 million for all claims made. The board, prior to the renewal license, shall require the licensee to submit to the board satisfactory evidence that the licensee is maintaining professional liability insurance coverage as required by this section.
Thank you for that. Are there discussions on the Blex amendment? Jenna?
Okay. Thank you, Mr. Chair. I just want to point out to the committee that by adding in your previous amendment, naturopathic doctors to the healthcare stabilization fund, that comes with it malpractice minimums, which would be $500,000 per claim, and then $1.5 million in the aggregate. And so if the committee were to adopt this, it would create a little bit of a conflict. There aren't other professions that are part of the healthcare stabilization fund with its mandatory minimums that have additional insurance required. So this would essentially double the insurance that is required for every other healthcare profession that's a part of the fund. So your regular physicians would have that 500,000, 1.5 million, and then this would, it would increase that.
Thank you for the clarification, Mr. Chair. Most providers have both anyhow. So the 500,000 in healthcare stabilization is a minimum. And most of the carriers, like on the APRN, I'm very familiar with that. That's generally, most of them's $1 million. Thank you.
Representative Weichel.
Thank you, Mr. Chairman. I have a follow-up question for the revisor. I understand what the carrier of the amendment is saying, that many have additional liability beyond what's in the healthcare stabilization fund requirement, but do we have that prescribed in statute, or they just do that?
Thank you, Mr. Chair. There aren't other, not to my knowledge, I don't think there's other healthcare professions where there's additional insurance required in statute.
Committee, further discussion. Representative Bueller.
I think I know where my colleague is going, but I think this is overkill, so I will not be supporting this amendment.
Committee, further discussion. Seeing none, Representative Blex, you may move your amendment.
Mr. Chair, I move my amendment.
All in favor say aye.
Aye.
Opposed, same sign? No. Motion carries. Back on the bill. Any more amendments? Representative Berquist, do you have an amendment?
No, I have a thought.
Yeah, you do. On abortion.
Oh, but the abortion's already part of it, right?
No,
No.
that's yours.
Okay, I need to add that back in there. Well, I don't have it written.
They have it.
If you have it already written for me, that was very nice of you to follow up. Thank you. Thank you, Mr. Chair.
Do I have a second on the Berquist amendment? A second by Representative Blex. All right. You guys started scaring me there for a minute. Representative Berquist, will you explain your amendment?
We passed an amendment.
Carly, do you have the minor office procedures? Okay.
Oh, my God, I'm laughing my butt off.
Thank you. Are you ready?
Yes. Please explain your amendment.
Within the statute that's already in place, the change that would be made would be on line 17 of page 2, on page 7, or item number 7, before perform procedures involving the termination of a pregnancy would include prescribe, dispense, or administer drugs or perform procedures involving in the termination of a pregnancy. And that's what my amendment covers.
Thank you. Discussion on the amendment. Committee, I might bring your attention to page or line 7 because it scared me the first time that I saw this. And these are items that a naturopathic doctor shall not do. And so when I first saw that, so that's under that paragraph.
Right, thank you.
Further discussion. Representative McDonald.
Thank you, Mr. Chair. As I read this, I don't know that this is necessary, but I won't necessarily oppose it. I can understand why, out of an abundance of caution, someone might want to make this amendment, but I just see it as redundant.
Thank you for that. Further discussion. Representative Myers.
Thank you, Mr. Chair. I appreciate it. So I can't support this amendment, although I understand that maybe it's being done under the guise of protecting individuals who are visiting naturopaths. But this takes me back to a discussion I had on a committee this morning where we were authorizing CPC, or I'm sorry, pregnancy clinics to, provide information to individuals that is not necessarily medically sound. And I worry that we keep adding things of this nature to bills that don't necessarily need it. And so I cannot support this amendment, but I do continue to support the underlying bill. Thank you.
Very good. Thank you for that. Committee, further discussion. Representative McDonald.
Just very quickly, in my discussions with naturopaths, they have not been seeking this permission, so I'm okay supporting this amendment. But I was on the same committee with Representative Meyer this morning relating to pregnancy compassion centers, and I agree with her logic as well.
Committee, further discussions on the Berquist amendment. Seeing none, Representative Berquist, you may move your amendment.
Mr. Chair, I move my amendment.
You've heard the motion. All in favor say aye.
Aye.
Opposed, same sign? No. Motion carries. Back on the bill. Back on the bill. Representative Blex.
Mr. Chair, I have an amendment on clarification of minor office procedures. If the revisor would pass that out so that the left hand knows what the right hand's doing. Thank you.
Thank you.
Is there a second on the Blex amendment? Representative Berquist.
Okay, we heard committee quite a bit of discussion early on about definition of minor office procedures. So this is an attempt, hopefully this is a compromise, to try to define those a little better. And you can read that there on page 21, right after line 24, inserting the provision of care for the treatment of superficial lacerations, abrasions, lesions, and the removal of foreign bodies and superficial tissues, excluding the eyes and not involving nerves, veins, arteries, tendons, or ligaments beyond the superficial layer. Such procedures may include the use of antiseptics, topical anesthesia, and superficial punctures to stimulate healing, but shall not include suturing, invasive repair, facial or tissue excision, that's hard, surgical interventions, or the administration of general or spinal anesthesia. And if you got any questions, you can refer them to the vice chair. Thank you.
Thank you, Representative. Vice Chair Rice.
Thank you, Mr. Chair. Thank you, my favorite fisherman and hunter. This is something, when we were negotiating the amendment we discussed first, we ran into this problem and ended up not defining terms, because if you look at the box, for instance, how do you treat lacerations but you can't suture? How do you remove lesions but you can't excise tissue? There's some self-contradictory language there, so that's part of the reason why we went with the non-invasive and left it up to the Board of Healing Arts. So just wanted to point that out. Thank you, Mr. Chair.
Committee, further discussion? Seeing none, Representative Blex, you may move your amendment.
Yes, sir, Mr. Chair. I move my amendment.
You've heard the motion. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. Back on the bill. Any more amendments, anybody? Last chance. Okay, very good. I'm going to call the question. Okay. All in favor of? Go ahead, Representative Bueller.
Yeah, thank you, Mr. Chair. I move that we pass out House Bill 2366 favorably as amended.
Is there a second? Second. Second by Representative Rees. Now we vote. All in favor say aye. Aye. Discussion. I'm getting ahead of myself again. Discussion. Representative Bryce.
Thank you, Mr. Chair. I just wanted to point out a couple of things that might be misunderstood. One is kind of the previous comments. I appreciate the comments about different classes of medical naturopathic professionals having conflict. Let me just point something out. And this might be counterintuitive to many, but I'm probably one of the most pro-naturopathic people in here. And I know you don't believe it, but when I first saw this bill, I thought, I've worked with naturopathic doctors, and it was in a state that didn't license naturopaths, but it was naturopath lookalikes or naturopath grads. And I hired them, I collaborated with him, we talked about collaboration. We collaborated, referred each other patients. I promoted that. And when I first saw this bill, I thought, well, good, naturopaths are going to be expanding. Maybe they can't get in nursing homes. Maybe they can't, treat people in hospitals. Maybe they need help practicing naturopathy. But then when I saw the bill, it's not expanding the ability to practice naturopathy. It's changing apples to oranges. It's changing naturopathy to diagnosis, prescriptions, and procedures. That is the definition of the practice of medicine. And so I think for public safety, the reason I did my best to negotiate with all the groups here is just like with the APRNs and the collaboration, there needs to be an on-ramp or a sequential or a period of time like a co-pilot where when people are going to change from basically one discipline to another discipline. And I know naturopaths take pharmacology, but taking a pharmacology course does not equate to treating a patient, writing the prescriptions, dealing with them. There's a lead in that is necessary. So I did my best, and I didn't mean to cause conflict, but I did, no good deed goes unpunished, I guess. But I tried to get things that the medical doctors want to do, things the naturopaths want to do, and neither group was happy with what I was doing, but sometimes that's what compromise is about. And I think this bill, without being amended, as previously said, it does expand the scope of practice of naturopaths significantly, allowing them to prescribe pharmacologic drugs, do procedures, things, and even beyond what an APRN or PA can do without physician collaboration. And I think, you know, I'm not trying to be contentious. I feel like earlier in the meeting, there was some contention. I'm not trying to be contentious. I just think if we're looking at public safety, we need to take a deep breath and look at, make sure we know what we're doing. It's not expanding naturopathy, it's changing apples to oranges, and there seems to need to be a process and so forth. So the bill currently, I appreciate the amendments that were added. I cannot support the current bill, but I appreciate everyone's efforts. Thank you.
Thank you very much for that committee. Further discussion. Representative McDonald.
Thank you, Mr. Chair. You know, we have a lot of partisanship and divide in our world, and on occasions like this one, I can agree with my friends across the aisle. I really think it's a celebration, so I'm happy to support this bill. Thank you.
Thank you for that, and I might just to elaborate on what the Vice Chair said, we've heard that before about public safety, and APRNs were going to kill everybody that they ever worked on, you know, and we heard that for years. It's been a non-event, and I just think that this is what this committee started out to do, was increase access to health care, and this accomplishes that goal. So with that, Representative Bueller.
Made the motion.
Oh, with that, all in favor say aye. Thank you all for your hard work, and you'll be getting out of here before 4 o'clock on a Friday night. So